Hi, everybody. Welcome to the Patti Brennan Show. Whether you have $20, $20 million, or $200 million, this show is for those of you who want to protect, grow, and use your assets to live your very best lives. Hey, everybody. I am so excited about today's show. I have with me Martin Shenkman. He is an estate planning attorney extraordinaire. This guy is so prolific and so smart. He's written 40 books, over 1,000 articles. And before we started today's show, he and I were riffing about all the different things that we both find in this particular area. So what I think the real issue that we find, Martin, and by the way, welcome to the show first.
Two things before we start. First,
Yeah.
my wife's name is Patti, and she spells it with an I like you.
No
So
way.
if I say
Really?
something inappropriate, just forgive me. And
Uh,
second, you got to call me Marty. The only person in my life that called me Martin was my mother, and it always meant I was in trouble.
Agreed. It's like me
Okay.
with being. Okay, Marty, thank you so much. Well, you know what? It is such a joy to have you here. You're so smart and you're so articulate. You know, you and I both agree, right? Many people go into this estate planning thinking they've got a will, they've got a trust, they're done, right? Everything's in place.
Absolutely.
And then we find out, well, wait a minute. The legal, the tax, and the financial pieces aren't working together. It's not coordinated. The family's not involved. The values are not really included in that. It's really a mess, but people are putting their heads in the sand and they're thinking that AI is going to solve the problems, and it doesn't. So basically, what we want to talk about today is the difference between having documents and having a really well coordinated plan. And you and I both do very sophisticated planning. We're going to take one tool, a very popular tool right now called a Spousal Lifetime Access Trust. And let's break that down.
Can
So,
I sneak a couple of quick comments in? Because you said
yes.
like all these profoundly important things.
Okay, go for it.
First, in fairness to regular people, not advisors, part of the problem why they think estate planning means getting a document is because the online services sell them that hype, right?
Right.
You come on X dollars, you get a trust, you can check it off and you can forget about it. That almost never, I would say never, but nothing's
Yeah,
ever absolute,
right.
but it would almost never accomplish what anyone needs, regardless of how much wealth you have.
Yep.
Second, you made a comment about sophistication, and it's really important. Just because you're not uber wealthy doesn't mean you don't need sophisticated planning. Life for a lot of us gets really complicated. And I'll give you an example we didn't even talk about, and maybe we'll do another show on it.
Hmm.
Religion. If you
Oh,
have deeply held religious beliefs, every faith has different implications to your planning. If you have health issues, the way you handle your documents and the way you structure the planning around those documents can have a profound impact on you being secure and safe. So don't tune out when Patty says sophisticated. Lots of people of lesser wealth need it, but too many people just want to check the box and say, I got a document. You're not accomplishing much of anything.
it's so interesting because I get the comment all the time. I have this big, thick, document. I don't know what it says, and it's got lots of things in there that I don't even understand and I'll never need. And basically, what I try to say is, look, here's the thing. We are trying to anticipate every possible thing that could happen. If it's not put into your document, the different scenarios, the different what ifs, then you know what? Your family's not going to have potential solutions because it was so simple. Just give it all away, or everybody gets it at age 35. What we were talking about before. Why? Why are you doing that? Right? It might
It's
be
it's
simple. It's not. It may not be the best thing for your family.
it almost never is. And when you give outright assets to a child or other heir, and if I say child, it could mean any heir.
Yeah.
We're not being judgmental, but we live in the land of the lawsuit. The litigation environment here is crippling. We have a 50% divorce rate. Um, there's a 20% of people in our country will have a mental health issue over the course of their lifetime. The list goes on. Why would you not have everything in a long-term trust?
Hmm. I
And it's not
agree.
simple. it's a mistake.
Right. And by the way, it doesn't have to be difficult for the child or the heir, to use your word. I like that word even better. Um, you can give them control. It's basically protecting that person that you want to receive what you've worked so hard for from predators. Predators could be a divorcing spouse. It could be, hey, you know what? Your kids could be driving a car, texting and driving, and kill a family. Who do you think is going to get sued? The child, the 16-year-old? No, they're going to go after the parents. And by the way, the parents are going to lose everything if it's not owned by a trust. So you
And
can,
by the way, let me
yeah,
sneak in. You as a parent, meaning the people listening, do not own a car that your teenage kid drives. Let them own the car. If they're 18, put the car in their name. Why should you have the liability?
right. That's a
But
really
those are
good
the kind
point.
of things that go beyond the documents that get overlooked. But what you're saying, Patti, is so critically important. Protecting assets is something everyone must do. And everyone kind of does it. They buy insurance. But how many people buy insurance and don't have an excess personal liability
I know.
policy?
I know.
You,
It's
you, you got
crazy.
to fill those gaps.
And you know what? I can tell already how good you are because I mean, I've known you and I know how good you are because of the way that you look out for your clients. And you're bringing these things up that may not have to do with any standard estate planning document that you can get on one of these online systems that don't do anything and they lull people into a sense that everything is done. It's not done. It's not done the right way. And you know, to me, a true legacy is leaving what you've worked so hard for in a way that the family and your heirs can receive it and basically continue its growth and protected from predators. That's the most important thing. So let's talk about a SLAT.
Let me interject. You're
Yeah.
saying all these good things, and then you're running
Yeah,
on.
yeah, yeah. Sorry.
Something that I started saying, I came up with it like 40 years ago, early on in my career, because I would watch what inherited wealth did to the recipients. Estate planning should not merely be about the transmission of wealth, but also about the transmission of values. So
Yes.
another whole topic, and this is something financial advisors, I think, do a much better job of than lawyers as a general statement, is educating and preparing the heirs for the wealth. If you're not preparing those heirs, what's going to happen? It's
I
not going to
know.
be good.
I know. And to your point, things can get complicated very quickly. What happens if there's a vacation home? And do all the kids want to keep the home? Is it, do you want to put it into like asking really important questions so that you're not creating, you know, dysfunction after you're gone. Like set
I've
it
seen
up,
some of the
talk to the,
worst fights in my 40-year career over that family vacation
yep,
home where everybody wants it Christmas week,
right. Yeah, exactly.
right?
Right.
I don't care about March. I want it Christmas week,
And
from Christmas to New Year's.
they can't stand each other by the time they're done. It's just it is really
Yeah.
interesting. It can create big problems. So let's just have the conversation and set things up the way that makes sense for each family. And that's you're really taking a personal approach to their estate planning. It's beautiful. Okay. You and I both know there are plans that work technically on paper but fail the family. That's what we're trying to avoid. We don't want to fail the family, okay? So let's make sure that it's going to work. So here's questions regarding, let's talk about the SLAT. Let's go to the SLAT because that's
Sure.
a really popular tool. So I'm going to give it to you. Why don't you explain what a SLAT is and talk about how it works and how it can help clients and, questions that people should ask but never ask.
Okay. So a SLAT, Spousal Lifetime Access Trust, SLAT is the acronym, is a trust that and I'm going to use husband and wife because it gets too
Fine.
complicated, spouse
Yeah.
one, spouse two.
Yeah.
Husband creates a trust for wife. Wife is a beneficiary of the trust. In almost every SLAT that I do, I list the kids and grandkids and all future descendants because the more flexibility, the more income tax planning opportunity in the future, the more flexibility for asset protection. If somebody's getting sued or divorced, you don't give them money, you give it to somebody else. Spousal Lifetime Access Trust. Here's the concept, and I'm going to do something you may not hear all the time. I take my own medicine. If I didn't think it worked, I wouldn't do it. In 2012, my wife and I set up SLATs for each other. And the phrase, sorry to use technical terms, is non-reciprocal spousal lifetime access trust. And the idea there is my trust that I set up for my wife, Patti, not you, my wife, Patti, is a little different, materially different than the trust she set up for me. And you need to do that because otherwise the IRS could uncross the trusts or a creditor could pierce the trusts. So the concept behind a SLAT is, let's say we have $200 in our name and my wife put $50 in her trust and I put 50 in my trust. We've removed half of our assets from arguably from the reach of our creditors or the IRS, but we can still access 100% of our assets, albeit indirectly. So I'm a beneficiary of the trust she created. She's a beneficiary of the trust I created. So long as we're both alive and married, we can access all the money within reason. So it's an incredibly powerful planning tool. And when we thought the exemption was going to go from 15 million down to like 5 million or something like that, lots of married couples were using SLATs. That may well happen again. There's proposals in Congress now to reduce the exemption from 15 million to 3.5 million. And nobody should think that if Social Security is really in jeopardy and raising the wage cap means testing it, if those things don't solve the problem, and they may not solve it because it's in such a terrible hole, any tax change is up for grabs. So this kind of planning was powerful, remains powerful. One of the very important messages, people should not get overwhelmed, confused, or snookered. I don't know if that's a legal term, by acronyms. The traditional life insurance trust, which went by the acronym ILIT, I-L-I-T, Irrevocable Life Insurance Trust, it was a SLAT just by another name. And I've joked that, lawyers came up with the SLAT acronym because they wanted to charge more money than for the ILIT acronym. The reality is a SLAT tends to be, but doesn't have to be, it depends who's drafting it and where you're getting it, more robust and thoughtful than the old style ILIT, but they're all one and the same. And there's lots of variations in names. Don't get bamboozled by the acronyms. If you don't understand it, go time out and insist someone explain it in English. SLAT, S-L-A-N-T, is a non-grantor variant of a SLAT, which has gotten, that's worthy of a whole webinar. It's got some really fascinating income tax planning opportunities. There's a backdoor SLAT where one spouse can appoint the assets to the other to get them back to, say, the husband who created the trust if the wife dies. There's variations of SLATs called hybrid DAPs, and SPATs, and forgive the acronyms, but it's a way that if I create a trust for my wife, I can get access back to the money. And the reality is that when you're doing SLAT-like planning, if the attorney or the advisors are only talking that one acronym, you're missing out on a lot of opportunities. What works best for you?
Right.
And you need to have those conversations because, for example, SLATs are an incredibly powerful tool for very moderate wealth people. I've used them for people who are $2 or $3 million. It's not just people saving estate tax.
So let me ask you a question. Tell me how that would work, because, we have always been taught you want to fully fund the SLAT. If they don't have 15 million in 2026 to put into a SLAT, then it's probably not worth it because you want to use up their exemption. So you're using it for lower. Tell me more about that.
So what you've just pointed out is one of the critical problems with a lot of planning done in all areas.
Yeah.
People take a very narrow application of what something can do. And here's how a couple worth $2-3 million could use SLATs very effectively. Let's say you have a young married couple, and I'm going to just make it husband and wife.
Yeah.
Don't anyone get upset because it just gets too complicated. Yeah. Husband and wife are both physicians. They're both surgeons. They're really worried about lawsuits. Surgeons get sued once every 5 years, like a 20% per year lawsuit rate. It's awful.
Wow.
So they want asset protection. What most physician clients of mine that have wanted asset protection have done is they wait until they have enough money to start planning. Hey,
Yeah.
start now. So let's say this newly minted young married couple, they're in their late 30s, are both physicians, and they want asset protection from malpractice claims. And frankly, everybody should want asset protection
Yeah.
because, again, we live in a very litigious society. They could create trust today and put a few $100,000 in it. Is still, you've created the trust before you have a claim. If you wait for another 10 years
Right.
till you have millions to put in, you probably have outstanding claims, and it gets very nettlesome and tricky to be able to fund a trust when you have an outstanding claim. And when are you going to have a period of time, this is a rhetorical question, where you know for sure you're not going to have any claims? Start it now. There have been many court cases that recognize that when a trust is created long before the claim arose, it's much safer.
Hmm.
It's much safer. So you want to create those planning devices now. Now, practically speaking, if I were to do non-reciprocal spousal lifetime access trust for a wealthier married couple, I might put one in Nevada and one in Alaska with institutional trustees, because using an institution is safer, it's better administration. Using a trust-friendly state that's known for good trust laws is more advantageous. Using different states which have different laws for husband and for wife to make them further different, those are great tools. And you need to be in one of the approximately 22 states that permit what's called self-settled trust to do the variations that I talked about earlier, where the spouse creating the trust can get added back in. So that's a wealthier version. What do you do for that young couple that's starting, that is wise enough and prudent enough to start planning today before there's claims? You can create a home state SLAT with a family member trustee and give another person called a trust protector the power to move the trust, change the trustee, and when their wealth gets large enough to justify some of the additional complexity and cost, you can enhance it. But what you've gained is years of I'm trying to think of the word when you have wine sitting in the bottles.
Yeah.
Like,
It's basically fermenting.
yes,
It's
that's
been
I'm
right.
sorry.
Yeah.
You're getting years of fermentation to improve the quality of the plan instead of waiting, and you can do it much less expensively without all the complications and enhance it later, but you've gotten on the planning bandwagon. The other thing that's interesting, there's a concept when anybody funds a trust that you've committed a fraudulent conveyance. You've transferred money to this irrevocable trust in order to defraud or hinder or delay your creditors. Well, wait a minute. If you put in 200 grand this year and 100 grand next year and 150 grand in 3 years, it gets harder and harder to prove that you've defrauded your creditors, because you're not putting in everything you have. You're not doing it all at once. You're doing it over time.
I and you used the word that I was going to ask you about. So tell me about the word irrevocable, right? Is an irrevocable trust ever truly irrevocable? You've
It
mentioned a
used to
couple
be.
of, yeah, you've mentioned a couple of back doors that I really liked. So tell us more about that.
So um, make sure we talk about basis planning, because this is very
Oh,
cool.
this is yeah.
So
I got
don't let me off this program
no,
without basis planning.
got it.
So irrevocable used to mean that it's carved in stone. That was the exact analogy I used early in my career, where you can't change anything. But the world has evolved and changed. So, for example, there's mechanisms we can build into a trust, even though it's quote unquote irrevocable, so that there's some, not everything, some things can be changed. So, for example, you can give somebody what's called a limited power of appointment. So that can give somebody the right to appoint trust assets to another trust, and you can constrain that or broaden that within certain parameters beyond what we can do today. So a family member, a beneficiary, even a third party can have the right to appoint trust assets. You can name somebody called a trust protector, and give them authority to make certain types of changes to the trust. There's a concept that's become very common, and again, not without issue, but there's a lot of flexibility it provides, called decanting. I guess this is back to our wine example,
Yes.
where you create a new trust and you pour the old trust into the new trust. Now, in most decantings, you cannot really change who the beneficiaries are, but you can modify all sorts of administrative provisions. One of the most common reasons trusts are decanted, and I will tell everybody listening to this, if you have an old trust, see when it ends. If it pays out to kids or grandkids at age 30 or 35 or something silly like that, and silly is a strong term, but it's
Yeah.
apt,
It is silly.
decant it, have the trustee decant it into a trust that's longer term. Why would you put assets into somebody's name at a specified age? If they get sued, divorced, or have an addiction issue
Yeah.
the next year, they could lose everything. So decanting, one of the most popular and common reasons, is to extend the term of a trust to protect a beneficiary. And it doesn't mean you don't trust the beneficiary. It doesn't mean you're
Right.
denying them. You're trying to protect them.
Exactly.
So
You're saving them from themselves often, because you know what? That's what we want to make sure, that that whoever you want to receive these assets, receive them in a way that is completely protected and from the predators and from things that can happen. And things are always changing. That's the beautiful
always.
thing about what you're talking about here, because I have read trusts that were set up in the 40s and the 50s, the 70s, and they're archaic. They don't take into consideration. I will tell you another one of my pet peeves, the word shall. The trustee shall pay income, shall pay this.
Bad.
Bad,
Very
bad,
bad.
bad. The word may is so much more flexible. If you trust this person to be a trustee or this institution, give them the power to make a judgment call based on what's happening at the time. So don't force their hand. That's what I think that, to your point, the way these things are done is so important, and somebody's got to read them and understand the implications on everybody involved. The
The
idea of,
problem,
yeah,
Patty,
go
is
ahead.
that most people feel that trusts are standard. There's no such thing as
No,
standard. There's no such thing as standard. And the reason, just to make sure people understand, because what you said is very important, you don't want a mandatory payout unless it's required for tax reasons, like a Q-tip marital trust,
right.
because then the creditor or the divorcing spouse can attach that income stream. You don't want a mandatory payment unless it's legally or tax-wise required, because if you can sprinkle the income, it will give you the flexibility to sprinkle income to somebody in a lower income tax bracket, and you can save a lot of money overall for the family. And what you're pointing out is so important because you're demonstrating why you don't just check the box and get a trust. What kind of trust are you talking about? What are your needs? I
Exactly.
mean, and by the way, that's where the team approach comes in. If you have a client that you've worked with for years, you kind of know what they want. You know what their circumstances are. We can hit the ground running, but let's start with the foundation. What are the client's goals? What are their circumstances? What are their family relationships?
Exactly.
What are the assets that they have? Different assets and different goals and different family members all require different planning and different results.
And that's a really good point, even right there. You don't, not fair isn't always equal. You can identify
That's another topic worthy of a whole discussion.
yeah, yeah,
But you
exactly.
see, forgive me for interrupting, but we talked earlier, and I don't remember if it was when after you started recording or before, about
Yeah,
this obsession that too many people have with simplicity. And my concern is I like simple too, but I like to define simple as the outcome being simple,
right.
right? Not the document or the plan. The plan shouldn't be more complex than necessary to increase the likelihood of a simple outcome. A non-simple outcome is where everyone's suing everybody and it costs a fortune and no one ends up talking to each other. A non-simple outcome is complex, difficult tax issues. Good planning may be more complicated, but overall, you've given a much simpler result to the client in the end.
It's so good. All right, let's talk about basis planning. I'm very
Okay,
curious about this.
so let's talk in English first. Let's
Yeah.
define what it means. So you bought a stock, Patty,
Hmm.
for $5. and it's now worth $1,000 a share. And you really feel now that you want to kind of get out of that stock and reduce your concentration risk. But you know that unless you put it into a charitable remainder trust or you combine charitable giving or something else with the planning, you're going to get tagged with a big income tax cost when you sell it. Now, nothing wrong with selling it and incurring an income tax to get some diversification because you don't want, my mommy always said, you don't want all your eggs in one basket. But is there potentially a better way? Enter the SLAT planning, spousal lifetime access planning we just talked about. So when this young doctor couple, going back to the same hypothetical, set up their SLATs, they each had an elderly parent, and their parents don't have a lot of money, and they actually are helping their parents financially. Not an uncommon scenario, not required, but just to paint the picture.
Sure.
So what we did is we made the husband's parent a beneficiary of the trust he created, and the wife's parent a beneficiary of the trust she created. And using the same concept, there's no mandatory distributions. It's all discretionary.
I have
So
a
you
question. I have a question. They are just a beneficiary, so you can have more than one beneficiary. The parent was just one beneficiary
correct.
of many,
In
of
the
several.
Spousal Lifetime
Yeah.
Access Trust that husband created, wife is a beneficiary. All of their descendants are a beneficiary, and we added in wife's mom.
Got it. Thank you so much, Marty.
Wife's mom is 92 years old and has a very modest estate. And in fact, the daughter and son-in-law are actually sending her a check a couple times a year to help her out.
Okay.
We give her what's called a general power of appointment. It's a technical term in the tax law. In English, it means she can designate who gets those assets on her death, and the group of people that can get the assets has to include either her creditors, her estate, the creditors of her estate. So she may be given a very finite, limited power, the wife's mother, to appoint trust assets to her creditors, of which she has none because she's just
Right.
on in years and not doing crazy stuff like young people like me and you do. You're
I love it.
welcome.
Yeah, I love it. You know what?
So what happens because mom has this general power of appointment on death, all the assets in the trust the young couple created are included in her estate. So the stock that was bought for $5 a share and is now worth $1,000 a share, up to her $15 million current exemption, the entire trust asset base is included in her estate. All those capital gains disappear because on death, assets included in your estate get what's called an adjustment. Some people wrongly call it a step up. It could be a step down too.
Yeah.
They adjust the value to fair market value at death. So the stock that this young couple paid $5 a share for that's now worth $1,000 a share, simply by including this power of appointment to mom, it's included in her estate, and all their capital gains disappear. They can sell whatever they want tomorrow and not have any capital gains cost. So let me make two comments. There's lots more detail on this, but I don't want to get too deep because I want to stay big picture. But when people what you stated earlier, that you use SLATs where you fully fund them to, get the estate tax exemption, it can be a hugely valuable tool for much lesser wealth people. We've already talked about how we can create a SLAT that's great asset protection, right? Because it's harder for creditors to get it, and how you can start early. Now we've added to that, you can get a basis step up. So you got asset protection and incredible income tax planning benefits. So what we've done is taken a tool that on the surface is viewed as only for those that we'll call very wealthy, 30 million and up, and now just made it very practical and really valuable for somebody that may only be worth $1 million or $2 million. And I've also told you how to do it on the cheap using a family member trustee, which I usually prefer not to do, using your home state, which I usually prefer not to do. And you can always try to enhance it later, but at least you got it going.
Mm-hmm. So that is a fascinating idea. So based on what you're telling us, then even let's say that there's 3 beneficiaries, and beneficiaries of the SLAT, and mom being one of them. It's not that she has the general power of appointment on a third of it. She has general power of appointment on all of it.
Correct.
That is fascinating. Has that been tested in the courts at all? Has that been tested by the IRS?
I can send you like a 100-page paper I wrote on it.
Wow.
Promise it'll work better than any of those sleep aids. One of the reasons I painted the picture I did of it being a parent, not some unknown
Right.
person in a nursing
Yeah.
home that you just befriended. I painted it that the parent is a current beneficiary, not just what's called in the tax law a naked power holder. I painted that they're actually helping the parent through the trust. So there's a history of the parent knowing about the trust and getting benefit from the trust. I've tried to paint it to be a more realistic plan than what some suggest may work. The law is not clear how far you have to go, but that's also an important concept in planning. The law may permit or be silent on certain things, but from my perspective, if I can use what I'll call common sense and be a little bit further away from that line, why not?
Hmm. Yeah, because the IRS is not going to knock on your door and say, "Oh, by the way, you didn't know about this. Let me give you this money back," or "Let me give you that basis adjustment that you didn't know that you could have."
No, they're
So
not going to do any of that.
nothing.
And part of the thing too, right now, the IRS has been decimated financially and really is in a tough position to audit the way they need to audit. If some future administration really wants to raise money for all the social programs, reducing the deficit, it ain't just about raising tax rates or a billionaire's tax. It's about giving the IRS the funding they need to do their job right. So people that are violating the law can get nabbed and pay their share of tax. And I think that's coming. I think it's short-sighted and frankly foolish to say, there's no risk, there's very low risk of an audit. I'm going to just be ridiculously aggressive. For the incremental cost to plan
Hmm.
more creatively, more intelligently, more reasonably, and like I said, take a little bit of a step back from that line. Um, why not do it? You don't know what the future is going to hold. And by the way, and this is an important point, most of these trusts have asset protection benefits if they're irrevocable, and a creditor could assert some of these issues too. So you need to be mindful of that.
I think you've brought up what I've learned from you today. So many things, by the way, Marty. You are so prolific. You are so smart. Is everybody's going to be different. The key here is what are the goals of the family? What are the things that they think about? What are the family dynamics? And simple is not something that's probably going to take care of the problem long term. Simple isn't always easy. Complicated isn't really complicated. Just give everyone options. If it's not in the document, you can't do it. So throw the kitchen sink in. That's my feeling.
Sometimes, but I think it's important that people that want simple, and I think everybody thinks they want simple,
Hmm.
define it properly. It's not simple today,
Yeah.
it's simple for the whole picture. So you want to do what works best and keeps it simpler at the end where the dollars and the issues really count. Can I give you a completely different concept to planning? And it builds on what you're saying, and it's a different perspective I have than most people that
Hmm.
practice law and draft estate planning documents. And it's very different than what a lot of these online services do. You look quite young, Patty, but did you ever was Lego did you play
Yeah.
with Lego?
Yeah. Legos were around. Yeah,
Okay.
absolutely. My
So
parents couldn't afford them. I'm one of 7 kids, so it's we were given a ball and said go out in the backyard and play. So that's basically
well,
what we
we'll have
had.
another conversation because we used to get really excited when a neighbor bought a new fridge or oven because we got the box.
Ah, there you go.
That was
Wow.
big stuff when I was a kid. But I did play Lego, and
Hmm.
Lego is sort of the framework or the paradigm for how I like to draft documents. What happens with most legal documents is you're getting a form that somebody has and pulls out of it. It used to be out of a drawer. Now it's, maybe
Hmm.
it's an online form or now it's in the law firm's database. And a lot of times now people are thinking they're going to mark that form up with AI, which is another whole
Forget
discussion
about
because
it. Yes. Scary.
it'll be there one day, but
It's
they're
not
missing the
there.
point. They're missing the point. That's the wrong approach because if I take a standard firm form that I have and I mark it up for Patti, the amount of changes I can make are limited. And it's not that I want to make a lot of changes, but I want a trust document, if we're talking, since we're talking about trust, that works for Patti and her circumstances and her goals. And if you have 5 people with the identical family and assets, their goals and their wishes may be different. You got to find out. I
Exactly.
would rather cobble together the parts of the puzzle, the building blocks, the Lego blocks that work for you. If I'm just giving you a marked up form, what are you getting? A marked up form. If I can build in blocks that make it work better for Patti, that's a much more advantageous form. And I'm going to give you an example. And I'm sorry to be technical, but I just want to get the
Go
point
for it.
across.
We've got
So
great
so
listeners.
let's
I'm
say we're
sorry.
doing a SLAT. Patti, I don't know your wealth level, but are you concerned that if your spouse dies and you can't get indirect access to the trust you created for your spouse, do you want to have access? So now we're going to build in a self-settled trust where you can be named a beneficiary or some variation of that. Well, that's a different building block. Most lawyers don't do that. But a SLAT can be one SLAT and one SPAT. A SPAT is a special power of appointment where somebody can appoint assets to you. And we can talk about the pros and cons. Different building blocks. Should you be given the ability for somebody in a non-fiduciary capacity to loan you trust money? Generally, yes, not always, but why? Because if somebody doesn't have a fiduciary responsibility to the beneficiaries, say your spouse and kids, they can loan you money without any regard for the impact on the other beneficiaries. But that's another way for you to access money in your own trust. Which building blocks do you need? I will tell you, every building block I add adds a little more cost, not much, because it's checking a box in a drafting software, a little more complexity, but it's the Lego blocks to build the
Mhm.
trust that you need. It's not a standardized form. And I think that if people took that approach, first, the consumers would understand it better because you can explain the building blocks. But with technology, it's not that big of a deal to really tailor something to precisely what people need.
So in that example, what would be the downside to putting it all in there? And then whoever is the trustee then picks and chooses based on facts and circumstances at the time.
So it depends. And that's the standard lawyer answer for every question that's
Yeah.
ever been asked.
Uh-huh.
If you don't need to have the ability to get added back as a beneficiary, you really don't. And that's really a financial question. Want to
Mm-hmm.
see what the
You
financial
bet.
advisor has done some modeling on. And that collaboration, coordination with the person drafting it and the person doing the forecasting, and also the insurance person who may be different. If you don't need to get added back, I'd rather not do it because the law is not perfectly clear that that works, although there is some case law supporting it, and there are laws in now over 20 states that permit it. If you don't need that added risk, I don't want to just throw it in. And you
Okay.
see, if you start with the kitchen sink,
Yeah.
that's and I'm not conceptually disagreeing because sometimes if when in doubt, put it in, but not for everything. I don't want to give powers that could undermine your plan unless you need them. And here's a fascinating thing that, again, is worthy of a whole discussion.
Mm-hmm.
If this planning is done right, the wealth advisor is intimately, integrally involved in the planning. Why so? When will the client need to touch this money? Will they ever need to touch the
Right.
money? So maybe instead of adding you back as a beneficiary, which creates a higher degree of risk, I'll permit a loan provision because you don't look like you're going to need it based on the forecasts, but we'll give you that as a safety valve. Maybe that's enough. Maybe a tax reimbursement is enough. Maybe a loan and tax reimbursement's enough, and I don't need to add you back. In the
Very
trust
interesting.
that one of the trusts that I created for my family, I can be added back as a beneficiary because I felt when I set it up that in my retirement years, based on what I was seeing then, I really wanted to take the extra risk to know that I could have the extra access.
Mm-hmm.
Maybe I change that decision now. But that's a decision the client should make based on informed information from the insurance consultant and the financial planner, not just legally. the financial and
Mm-hmm.
insurance decision should inform what the legal drafts person may do. I'll give you a perfect example. So we've been talking about non-reciprocal SLATs. Husband sets up trust for wife and descendants. Wife sets up trust for husband and descendants. So long as wife is alive, the husband can indirectly benefit from the trust he created for her. So if the wife decides that she's going to buy a ski chalet in Boulder, Colorado, then she can decide because her husband is behaving that week, he can come and visit at the ski chalet. So he can indirectly benefit. God forbid the wife dies prematurely, that indirect benefit is fully cut off. The husband's not a beneficiary unless you do the self-settled trust. But if the couple is young enough or healthy enough, or especially both, the wife and her trust could buy a couple $1 million insurance policy that may be all that's necessary. That may be viewed by the client as less risk than the provision adding the husband back as a beneficiary. So you're weighing all the pros and cons with the input from the other advisors so the planning is coordinated. When it's like an orchestra. When all the musicians play in harmony, you really get some much better music than when anyone's just going off on a tangent. And that's the model for what planning should be. The Lego approach to tailor the planning, because with technology, it's not that much more costly and it's much better refined. And I think it's more supportable when it works for you. The insurance planning, because it can backstop it, as I just illustrated, the financial forecast, and then you can the client can make informed decisions. How much risk do they want to take? Because listen, if I could buy a $2 million insurance policy for a 10-year term, and the financial modeling shows that once I'm past 10 years, we got enough money, I don't care to get access, why should I take on more legal or asset protection risk?
It's a really good point. And these questions that you're bringing up today, they're very practical. There's always a solution. The question is, what do you want to do? You've got so many different ideas and so many different approaches, and that's the most important thing. It's not a cookie cutter approach. You don't want cookie cutter. That's not going to give people the outcome that they really want.
But people seem to go for that because they don't appreciate what we're talking about,
Mm-hmm.
and because they're being marketed to and sold on the idea, come to this online. And I'm not dissing
Yeah.
online websites, and I can tell you how to get better documents out of online websites real quickly, because some people can't afford to go out and
Sure.
hire all the advisors.
So,
But the concept that you can just get a standard document, it's
mm-hmm.
really, it doesn't even work for people of modest means in many
Mm-hmm.
cases.
Yeah.
By the way, here's a couple of quick points.
Good.
Somebody that really can't afford to get an attorney and do it, they have no choice perhaps but to go online. And if you go to one of the online services, I'd rather you do that than using AI, because you don't know where the AI is drawing from. And the online services at least advertise that their documents are valid in all 50 states. So there must be some truth behind that. I can't
Mm-hmm.
guarantee it, but I would think there would be. So one, go to a reputable large online service. Number two, and this is the biggest complaint I have about online services, do not go and draft a will or a trust. Go get educated first.
Right.
Find videos on YouTube. Find articles to read. Get educated before you turn on the program. If they really cared about what their customers were getting, they'd make you watch a 30-minute or 60-minute video training you and educating you about the document you're about to unlock.
Mm-hmm.
They don't do that because their job is not to get you a good result, but to sell products.
Right.
And the third thing, which nobody does that I've seen, and it doesn't have to cost anything, don't do it alone. One of the biggest benefits clients have from talking to an independent lawyer, an independent wealth advisor, we're objective.
Right.
We're not only trained to be objective, but we're just not part of the client's inner circle where we're like, we're listening to all the baloney. If you're going to do an online document, find a couple of close friends or even relatives, but not those named in the document. Do the stuff together.
Yep.
Because even a close friend can say, hey, Jane, what are you talking about? Your
right.
kids hate each other. You can't do that.
Right.
You need objectivity. You need a different lens. So if you get educated and you get some objectivity. And the third and final point, keep it simple. When you're making the decisions as a layperson using an online drafting software, they have way too many options. They do that to attract people, not to get you a better result. The more options you have, and the more you tinker with the output, changing it and modifying it because you think you're a lawyer, the worse it's going to be. Keep it simple. Get a friend or family member to be objective. Get educated first. So I don't like to say never use online because people need it. There's a place appropriate for everything.
There sure is. And I appreciate that practical approach. All excellent points. Marty, you are incredible. So the listeners, people who are watching.
Can you call my wife, Patti, and tell her I'm incredible when we're done?
You are incredible. You really are incredible. So let's close this up with really what are action items that people listening can take? What's the next best step? They have documents. What do? Do they go to their existing attorney with the ideas that you've brought up? What's the next best step?
I think, first of all, how old are your documents? The world is changing at an increasingly rapid clip. And if you've been fully invested in the market, your financial situation may be different. The tax laws have changed every time there's a new administration and even sometimes in between. So you need to review and keep stuff current. I like having a planning team because, we all hear horror stories of some bad lawyer advisor, snookering a client. When you have independent advisors, that's not going to happen. Take a holistic, comprehensive view. If you have an attorney and you're comfortable with them, by all means, you go back to them and review your plan. Listen to what they're telling you. Is there more you could be doing? If you've been told in the past, and Patti said what most people believe, that unless you're going to use close to the $15 million, you don't need a SLAT. It's not true. But there's lots of other options. What works for you? I think everybody should sit down and assess what are their goals. Everybody needs to have a personal financial statement. If you have a financial advisor, I'm sure they're doing that for you. You got to identify who owns what, the title to assets, right? Because you could have the best will or rev trust in the world and all your assets are POD and nothing goes through your estate plan.
Right.
Get the plan coordinated, get it updated, ask questions. Right. And you can even ask, hey, lawyer, what questions do you think I should be asking?
Right. Mm-hmm. Exactly.
And final, and I would never tell a client not to use AI because I use it all the time. It's very powerful. The difference between me and the client using AI is I've been doing this for over 40 years and I've written like 44 books and 1,400 articles, not to correct you. But I have a deep well of knowledge and perspective to ask good questions of AI. And if what AI gives me back is wrong, I can usually sniff it out. Mm-hmm. So you can use AI to formulate questions and think of things, but just be mindful that when you don't have any expertise in this area, what you're asking may get you down a path of, the rabbit hole where you're just asking endless questions that don't really work. But talk to your different advisors. Get your advisors together on a Zoom call.
Yeah.
Right? Bring in your family member. Bring in your best college roommate that you think is so smart and authorize them to be there. It'll taint attorney-client privilege, but have a robust discussion. I find that almost everybody can improve the planning they have. Too often when planning is done, it's not done in a comprehensive, broad, holistic way. And if you take that look at all the different things, whether it be religion, health issues, addiction issues, income tax, estate tax, asset protection, you want a plan that does what you need. Half those things may be irrelevant to you, but then you still have half that are relevant, and you want to make sure they're addressed.
Exactly. And you never know because changes are occurring every single year.
All the time.
All the time. So thank you, Marty. Thank you so much for being on the show today. I've learned so much. I know our listeners have learned so much. You really are incredible, by the way. And tell your wife you should record this little bit and send it to her and just say, hey, Patti Brennan says I'm incredible. You are really, really good. And
listen, with your first name, that may count more.
Yeah. Well, I will tell you what really stood out to me was the fact that you were bringing up the different states, Nevada, more friendly states with, trust law, et cetera. It tells me that you really care, that you're thinking this stuff through and you're keeping really updated. So thank you for that. Thank you for being on the show today.
Listen, your little motto under your firm name, wisdom and care. That's what everybody should want.
Yeah,
Wisdom, care, and knowledge.
correct. Yep, exactly.
Yeah. And by the way, what you said is vital. Make sure your advisors are keeping up because the
Oh my
world is
God,
changing so rapidly.
exactly.
And there's always new cases. Even if you don't hear of a new tax law, there's just a very significant asset protection trust case in Delaware and one in California that are quite important to
They are
what you
really
can and can't
important.
do.
Right,
Yeah.
exactly. And that will inform the documents, and that's why you need to update
Yes.
them and make sure that you're talking to people who are keeping up to date and relevant with new case law, because that's what everybody has to go on.
Right.
So so thank you
And
so
that's why the
much.
team approach makes sense because if anyone on the team, the accountant, the attorney, and financial advisor, the insurance consultant, if somebody is like missing the boat, somebody else is going, hey, Jane,
Yeah.
they're not with it.
Exactly. And boy, I don't know about you, but I have been involved after the fact with disasters where people had somebody do their estate planning who really wasn't an expert, and it turned out awful, especially here in Pennsylvania. Look out. Make sure the person knows what they're doing. It's really, really important. I'm just going to throw it out there. Joint revocable trusts, be very careful because we have something called tracing in Pennsylvania where it could really create a problem for the surviving spouse.
That's
So,
another interesting topic worthy of a webinar
yeah.
because they're almost always done wrong.
Yep. Yep. Exactly. Oh, we could talk about just trusts and all that kind of stuff, but we won't get overly
But
technical. Let's
don't
get
jest with me.
right, right. We'll do that on the side. Thank you so much, Marty, for joining me today. This
Take
was a
care.
lot of fun. Thank you so much. And thanks to all of you for joining us. Again, if you have any questions, oh, Marty, while I still have you, how can people reach you? I want people to be able to reach you. No?
I have a free educational website, shenkmaneducation.com.
Love
And
it.
there's tons of material. We have hundreds of webinars. I've been doing short consumer-oriented video clips covering even very sophisticated topics like a lot of the stuff we've talked about. And there's hundreds and hundreds of
Wonderful.
articles. We're adding to it every week. So get
Thank you.
educated first. And I think that's
That's the
a,
most
a,
important
a
thing.
a free and reasonable way to do it. And I really do try to educate people, not there's nothing sold on the website. It's
No,
just
that's
there to help.
beautiful. Thank you so much. Boy, thank you so much. You are wonderful. Thank you for joining me today. It's wonderful to have this relationship with you, Marty. And thanks to all of you for joining us. If you have any questions on anything that we've talked about today, go to our website, www.keyfinancialinc.com. Ask us your questions, reach out to us. We're happy to help you any way that we can. Thanks again for joining us and have a great day.